Well, this is awkward. When I agreed to respond to Stephen's paper, I had no idea that I would turn out to be the protagonist. When the mics invite me and to respond to a paper, I just say yes and actually don't even pay much attention to what the paper is until about 10 days before the conference when I start to prepare. I did look at the title, Optimistic Originalism, but it just did not occur to me that was me. I'm not that optimistic. Now, if the title had been, originalists who worry that we may be going to hell in a handbasket, I'd have said, I'll check his footnotes to see if that's if he's talking about me. But and so then when I did start reading the paper, not that long, too late in the game to call the mics and say, no, I really shouldn't be doing this. I see my name on the first page, and then on page 16, I find out that I have written the text of optimistic originalism. So this is awkward. And not only awkward, but a little bit difficult, because methodologically, I actually agree with most, or at least a great deal, of what Stephen has to say. I think I'm probably closer methodologically to Stephen than many of the people around the room. I think that may be what he meant in his initial remarks about people claiming that I'm not an original meaning originalist, which I completely disagree with, but I think that's probably what they mean. So he explains on page 10 what his methodology is. The better approach, he says, is to focus on the participants in the Reconstruction debates and the understanding they had of their own actions, and especially to look at the design and purposes of the amendments. And he contrasts this to a picture, maybe a caricature, but I think a useful caricature nonetheless of public meaning originalism, which abstracts from the actual historical participants and what they were doing and saying, using, he says, two principal distinctions. That is, a distinction between objective and subjective meaning, and also the idea that we do not look to original expectations. And using those two devices, they basically swap in for the actual views of the historical participants what Stephen calls a rational reconstruction of the past, what a reasonable person would have meant, and not what actual flesh and blood historical participants were saying and doing. To all this, I just say amen. I think that's entirely right. I'm not sure that that's what new originalism forces us to. I think it's kind of an extreme, but it is a tendency that we need to guard against. I think his paper is therefore a useful corrective to this. And so how does this work? So it seems to work by looking at the original sources, stating a principle from those, usually at a pretty high level of abstraction, a thin meaning, and then saying what we think those principles ought to entail. And this, as he says, can lead us pretty far from what any actual historical figure ever thought. Now, this reminds me very much of what used to be, Larry Tribe and Michael Dorff champion this method of constitutional interpretation. If this is what new originalism means, it's really not. We've gone back to a place that I thought was the other side. So So I'm really in agreement with Stephen about all of his important points, but I do kind of wonder about this text because I went back and reread parts of it, and it looks at what the actual historical actors did and what they said and what their theories were. It goes through 18 recorded votes in the House and the Senate, what the motions were, 4 recorded votes on the specific question of separate but equal, right? And talks about the results of every one of those, and the results I think are pretty striking. The Senate voted in favor of desegregation legislation by a vote as 23 to 30, and the House 91 to 114. Now these are shy of 2/3. I'm not sure that matters, but these are not small majorities, right? And so I think this is actually pretty important. And then the text looks at the explanations and also spends a great deal of time looking at the legal theories of the opponents and tries to assess how powerful those are. Turns out that there are 2 inconsistent bases for opposing this. You can't believe in both. So one group says, yes, schools are within the protection of the amendment, but separate but equal is okay. And another school says, no, the schools aren't privileges and immunities and aren't covered by the 14th Amendment at all. Those are not consistent positions. And it's interesting that, it's a pretty small minority that takes either of those positions. And so, what I would have said is that this article is the text of Griffinian originalism, right? Rather than the target of it. So what does he say? What are the specific criticisms? He says first on page 32, he notes that there were a lot of controversies over all of these propositions. Well, okay, that seems right. The text actually devotes 60 pages to these controversies and lays them all out and tries to see how they fit in with each other. Another complaint is that McConnell's evidence here depends upon views expressed by some of the amendment's most fervent supporters, and goes on to describe it as the views of the limited number of Republicans who supported the schools provision. Well, this is not just the most fervent supporters. The majorities here are overwhelming. If you're looking just at the Republicans on the various votes, 70%, 99%, 90%, 94%, 93% of Republicans support the school provisions. This is not some, rabid, radical minority. And I think one of his main complaints is that the text ignores the opposition, that those people who are opposed to the 14th Amendment. Now, it doesn't actually ignore them. There are 9 pages on their views, but I do think maybe this is a point of disagreement, but I do think that when people base their arguments on something other than the meaning of the 14th Amendment, that we should, not ignore them, but it's not evidence about the meaning of the amendment. So what are we talking about? Here's Eli Salisbury of Delaware. I am placed under the most binding obligation to maintain for my race that superiority to which it is entitled by the decrees of God himself. And here in the council of my country, I proclaim that no act of mine shall assist to drag it down and place it on an equality with an inferior race. So he's against the bill. Right. Does that tell us anything about what the meaning of the 14th Amendment is? I think not, right? And so, and another criticism is that the text limits its analysis to the congressional debates rather than the wider debates around the country. I have to say, guilty as charged here. I didn't do that work. I'm going to worry about it when I see that the debates outside the halls of the Congress are, different from what was in. And Stephen's paper actually later says that they're approximately the same. So I do kind of wish that I had added an additional 50 pages to this based upon work which probably would have taken me 5 more years. I didn't do that. But I really don't think it affects the optimism of the piece. This may be a small point, but it's a little annoying. Stephen quotes a historian, Kate Mazur, for the conclusion that school segregation, quote, fell on the social side of the civil, political, social rights dichotomy. And that's, as if this had been ignored by the text, but in fact, the text devotes 9 pages to the social rights argument, and this was one of the principal arguments made against the bill. It was not ignored, and the supporters of the bill roundly rejected the claim that the right to attend a desegregated school was a social right. I don't have time. In fact, I don't have time for anything else, so I won't bore you with some of the delicious quotations about this, but it's actually some of the more interesting bits of the debate. So, it's been awkward because I so want to join arms with Stephen on, I think, some very important points that he's made about the methodology, but I wish he'd recognize that I'm on his side and is part of his club. Thank you.
I'll just reiterate that Michael, of course, deserves enormous credit for bringing this debate back to our attention, the debate over the 1875 Act, most of which occurred well before 1875, but you have to, read history books like Eric Foner's book really closely to even spot that there was a substantial debate over school desegregation. And that's why I think Michael's article had such an enormous impact. But just 2 quick points. First, I think we would have to acknowledge there are scholars, including originalists, who just reject reliance on post-enactment evidence. Michael just did a nice video for the Federalist Society. I would recommend it on YouTube, summarizing his basic case. It's all about what happens after the enactment, the adoption of the 14th Amendment, which after all is what we're talking about. And I think there are some well-known arguments against reliance on that post-enactment evidence. Now, I'm happy to look at the whole record, but I am saying, though, that despite Michael's enormous effort at trying to review all the arguments that were made in opposition, I am saying that he did miss one, and it's kind of important. And it relates directly to the cogency of original meaning, originalism, the new originalism, which is, there's just not much there about concern for federalism or states' rights. And there wouldn't be, right, in a philosophy that places so much emphasis on the text. If 19th century people were coming at it from a slightly different perspective, and not quite so focused on the text, more focused on structural doctrines, they might have objections that a text-based approach wouldn't necessarily pick up, and that's something I emphasize strongly in the paper. I could say some other things, but they should be left for the discussion.